Hi, I'm Shannon Farrell with the OSU Department of Agricultural Economics, and this video module is part of our presentation set from the project of Environmental Regulatory Compliance for Farmers and Ranchers. In this module, we'll be talking about land quality and waste issues for Oklahoma farms and ranches. The federal law that governs solid waste and hazardous waste is called RCRA, or the Resource Conservation and Recovery Act, and many states, Oklahoma included, have enacted state statutes that largely mirror RCRA so that they can have delegated authority to enforce RCRA within the state's borders rather than EPA. And that's one thing that Oklahoma has done. The Oklahoma Department of Environmental Quality largely implements the provisions of RCRA within Oklahoma. The overarching purpose of RCRA is to make sure that solid waste and hazardous waste are disposed of in ways that don't cause harm to the environment or to human health. And the basic overarching requirement is that hazardous materials and solid materials both need to be disposed of properly. When we're talking about solid waste, which is a defined term under RCRA, solid waste has to be disposed of at a permitted facility. We can't just dispose of solid waste anywhere that we want to. So in many cases, that means if we have waste on the farm, we can't dispose of them on the farm. We actually have to dispose of them in a solid waste landfill or use some other approved disposal method. And the definition of solid waste is pretty expansive, so pretty much any waste material that we have is going to be considered solid waste. And you'll note from the definition that waste material from agricultural operations is explicitly included within RCRA. Like we said, the basic requirement is that we have to dispose of these things in a permitted landfill, but in Oklahoma there is a very important exception to that. In Oklahoma, household waste, and household waste is defined kind of as you would think of it, waste generated by a household, so that may not necessarily include operational waste from our agricultural production operations, just household waste. But household waste can be disposed of on property so long as it doesn't cause any environmental harm. Lots of people will use that using basically an on-farm landfill. Some people will store that in pits or other containers. That is allowed for household waste, but remember, not agricultural waste. Agricultural waste will usually fall outside the household waste exemption. And this is a little bit of a tie-in to our air quality rules that we'll talk about in a separate module, but open burning for the most part is prohibited and generally is not an approved method for disposing of either household waste or agricultural waste. So, the old trash can burning out in the backyard or open pit burns, those aren't allowed under Oklahoma's air quality regulations. Also, an issue that we faced a lot in agriculture in the past, and still face to some extent, is tire disposal. Oklahoma also has statutes that explicitly requires all used tires to be disposed of for recycling at a permitted facility. So that's the solid waste side of things. What about hazardous waste? Lots of things that we generate on the farm might be considered hazardous waste, and the most common example of that is pesticide waste, which we'll also talk about a little bit later on, and also in our module talking about pesticide management. For something to be a RCRA hazardous waste, it first has to meet the definition of solid waste. And then, if it does meet the definition of solid waste, it has to appear on one of EPA's lists of wastes, and anything appearing on that list is automatically deemed to be hazardous. Or if it exhibits a hazardous trait, ignitability, meaning it's easy to catch on fire at room temperature or under common conditions. Corrosive, if it has an extremely high or low pH value. Reactivity, will it react violently with water, or can it form explosive mixtures in the environment that it would commonly encounter? And then toxicity, does it contain specified levels of defined hazardous materials that can be toxic to life? If something is a hazardous waste, it has to be disposed of at a hazardous waste disposal site, and also handlers of the hazardous waste, or people that generate the hazardous waste, also have to meet certain record-keeping requirements, can only accumulate so much hazardous waste, and have to follow several other requirements for its handling, treatment, transportation, and disposal. Now, the good news for us in agriculture is that when we're talking about the most common hazardous waste that we might have on hand, i.e. our pesticide wastes, those can be excluded so long as they're handled as crop residues from production, whether it's from crop production or animal production, used as a fertilizer. That means that we're using the fertilizer value of the crop residues or the animal waste materials in proportion to the nutrient management plan that we have in place for our facility. So simply disposing of those wastes on land is not enough. They have to be used properly as a fertilizer, and court cases interpreting that rule have found that if we're just applying the waste without regard to a nutrient management plan, that looks like disposal, not use. Okay, and that's one of the things that we've seen a lot, especially in poultry litigation and some other animal waste litigations recently, is that over application of the fertilizer value can actually result in that being regarded as a disposal and a potential RCRA violation. So disposing of hazardous wastes can get us into trouble with something called CERCLA as well, the Comprehensive Environmental Response, Compensation, and Liability Act. The basic goal of CERCLA is to make sure that if there is the release of a hazardous substance, that it's cleaned up as quickly and effectively as possible to minimize the risk of environmental harm. The trick of CERCLA is that it seeks to find the party responsible for the release, and that party has a financial liability for any of the reasonable cleanup costs that are incurred in responding to that release. Now, CERCLA tries to handle releases that don't have a responsible party through Superfund. You may have heard Superfund mentioned. You might even hear CERCLA referred to as the Superfund law. But that's basically a trust fund that's been created to provide monies that can be used for environmental cleanup. But remember, we only resort to the Superfund if we can't find the responsible party. If there is a responsible party out there, then whoever is engaged in the cleanup can find that responsible party and hold them financially responsible for the cleanup. Also, CERCLA allows states to recover damages for what we call natural resource damages. It may not be enough that we've cleaned up soil and remediated the chemicals that got into it. If we cause the loss of plant species or animal species and we have to repopulate them, those would be considered natural resource damages. Those are compensable under the Act as well. Well, we said that a party responsible for a release can be held liable for any of the cleanup costs, and that's the liability hook of CERCLA. CERCLA says if a party owns land where a release has been found, that is enough to cause CERCLA liability unless that person can then provide one of the viable defenses. So, buying property that has a release already occurring on it, even if you weren't directly responsible for the release yourself, buying the property can be enough to attach liability under CERCLA. Now, there are two primary ways to defend against that. Number one is to be an innocent landowner, also sometimes called a contiguous property owner, or a bona fide prospective purchaser. Either of those two defenses requires that we conduct what we call all appropriate inquiry. All appropriate inquiry is an environmental audit of the property made before it's purchased. Remember that. We can only have that liability protection if we make the inspection before the property is purchased. An all appropriate inquiry is an evaluation, basically an environmental audit of the property, conducted by an environmental professional, which could be a professional geologist, professional engineer, or a trained environmental professional with a specified amount of experience and oversight. But they'll investigate a condition of the property and look for anything that might indicate problems with the environmental conditions before the transaction's taken place. So remember, that has to take place before we purchase the property to get the benefit of those protections. So the moral of the story, really, for CERCLA liability is if there's any opportunity for potential environmental harm, do all appropriate inquiry before the property is acquired. Also note that if you're what we call a bona fide prospective purchaser, and that's one of the defenses that we talked about moments ago, you can buy property that has had prior environmental problems if you enter a plan of cooperation with the environmental agency that's relevant. Usually in Oklahoma, that's DEQ, to clean up the property and cooperate with that process going forward. Other than that, if you buy property and you find that it has if you buy the property and find that it has contamination in place and you've bought it, you could be a potentially liable party under CERCLA, and that's something that's definitely to be avoided. So very quickly today, we've talked about RCRA and the requirements to make sure that our solid waste is disposed of in a permitted solid waste landfill. We talked about the prohibitions against open burning of trash. We've also talked about the potential liability for disposing of hazardous substances inappropriately. If you have any questions, please make sure that you visit the agecon.okstate.edu website. Click on the extension link and find our environmental regulatory compliance page there. You can download the Environmental Compliance Handbook for lots more information about this and many other topics. Thank you for watching today.